For those of you that don't know me, I'm Judge Consuelo Maria Callahan from the U.S. Court of Appeals for the Ninth Circuit, but that's just my job. More importantly, I was a regent for this university for 9 years, so I feel comfortable welcoming our esteemed guest on behalf of the university. And as well, I live in Stockton and call Stockton my home. So I'm delighted that Dean Erwin Chemerinsky is here to be with us today. And he'll be formally introduced, but I want to thank the Dean for coming, and I want to thank him for all the years that he has devoted to legal education. What you may not know is this is one of the most generous individuals in terms of his time to educate the public about constitutional law issues. And it really does take a lot of time. He taught a class this afternoon at 3:30 in Berkeley, and he's the dean of the school. Then he had to jump in a car to drive here. And when you see him, well, I don't know if he's going to use a note for the first time of his life, but all of the many times that I've seen him, he never uses a note, and he knows all of the cases and is a captivating speaker. So I want to welcome the Dean to the University of Pacific, to Stockton, and all of you, and I'm sure that you will be very interested in learning more about your constitutional rights and speech on campuses. Thank you, Dean.
And I would follow up with welcome and thank you to Dr. Cindy Osberg, UOP Professor of Political Science and Director of Pacific Legal Scholars Program, which is responsible for inviting such a preeminent guest speaker to UOP this evening. And I know a lot of you. I'm Judge Barbara Cromlin, San Joaquin County Superior Court, and it's an honor and pleasure for me to be asked to introduce Dean Chemerinsky. We welcome and thank UC Berkeley School of Law's Dean Erwin Chemerinsky, a nationally recognized constitutional law scholar and regular presenter for California Judges Association, who will present free speech on college campuses, a timely and controversial topic that we as a free society need to address. He is a Harvard Law graduate who graduated cum laude in 1978. He received a BS degree from Northwestern University prior to that. The Dean is considered one of the nation's top experts in constitutional law, federal practice, civil rights and civil liberties, and appellate litigation, according to American Bar Association. Dean Chemerinsky just released a new book titled Free Speech on College Campuses. He accepted the position of Dean at UC Berkeley School of Law in July of 2017, having previously served as Dean of UC Irvine and faculty at Duke University, DePaul University College of Law, and University of Southern California School of Law. Dean Chemerinsky has published extensively and presents a regular column on the United States Supreme Court carried by the California Lawyer, the Los Angeles Daily Journal, and Trial Magazine. The Dean has argued a number of cases before the U.S. Supreme Court, and in March of 2011 was noted by the National Jurist magazine for law students as, quote, one of the 23 law professors to take before you die, a sentiment of which I wholeheartedly concur. In 2017, National Jurist magazine again named Dean Chemerinsky as the most influential person in legal education in the United States. Please give a warm welcome to our most distinguished speaker, Dean Erwin Chemerinsky.
That's so kind. Thank you. Wow. Judge Callahan, Judge Conlon, thank you so much for the incredibly kind introduction. As I was listening to all your sweet words, I just wish my mother was here, because I think my mom still wonders when I'm going to get a real job. It's terrific to be here. Thank all of you for coming tonight. I've often had the sense that every generation feels that it's the first to discover sex. I likewise often have the sense that each generation believes that it's the first to discover issues of free speech on college campuses. The reality is that issues of free speech on college campuses are as old as colleges and universities. Yet I also think that things have changed. My image, perhaps our shared image with regard to speech on campus, is the free speech movement from Berkeley in the mid-1960s. It's about students on campus protesting to have the ability to engage in speech on campus unrelated to university business. The administrators tried to stop their protests and demonstrations. Now, so often, though, the speech is outsiders from campus who want to use the college or university as their platform. It's people like Milo Yiannopoulos, Richard Spencer, Ann Coulter coming on to campuses here and across the country. Often it's outside groups trying to stop them. You might remember an incident at UC Berkeley at the end of January 2017 where provocateur Milo Yiannopoulos was to speak on campus, and the radical group Antifa engaged in acts of vandalism. And the threat to safety was so great that the then Chancellor, Nicholas Sturks, decided there was no way to continue the speech and protect safety on campus. Other things have changed too. I have the sense that student attitudes with regard to free speech have shifted. I taught an undergraduate seminar the past 2 years on free speech on campus at UC Irvine. And for each of the topics, we polled our students. I was stunned by how often our students took the anti-free speech position. A recent survey from the Pew Research Institute confirms this. 40% of undergraduates surveyed said they favor campuses being able to restrict offensive or hateful speech. I think there's many things that explain this. Some are quite laudable. This is the first generation to grow up from a young age being taught that bullying is wrong. They've internalized that message. Also, I think that this is a generation that's grown up without really having threats to their free speech. My students, at least, show remarkable trust in campus officials to make the choices about what speech to allow and what speech to prohibit. I realized in teaching my undergraduates that the Vietnam War protests that were going on when I was in college, or the civil rights demonstrations, are as long ago for them as World War I was for me. I sometimes think that my students equate free speech more with the vitriol of Yik Yak than the civil rights demonstrations of the 1960s. I also have the sense that things have changed, that I often feel that we've turned over a rock in our society in the last year, and an ugliness has become public that we rarely saw before, at least in recent years. I'm sure you all remember what went on in Charlottesville in August of 2017, where a group of white supremacists held a rally that ultimately ended in tragedy. But I don't know if you've taken the time to actually read the signs that were held up by those white supremacists in Charlottesville. For example, one sign said, and I quote verbatim, "Kikes belong in the oven." I'm 64 years old. I don't remember ever seeing a sign held up in public that said that. We had an incident at my law school, UC Berkeley, in September. Harvard Law professor Alan Dershowitz came to speak. He's controversial, he's conservative, he's an outspoken supporter of President Trump. He's also an outspoken supporter of the policies of the current Israeli government. It was tense. There was certainly the occasion for people to ask him tough questions that he responded to. But thankfully, it all went off without incident. That afternoon, though, someone drew a swastika over his picture that was on a poster on a law school bulletin board. I've been a professor 38 years now. I'd never been in a building, a campus, where someone drew a swastika on the wall. Well, all of this is the context for us tonight to talk about free speech on campus. Increasingly, I've come to realize that it's important to draw a distinction between a discussion of the current law and a conversation about what the law should be. I want to focus on the former, describing to you the basic legal principles concerning free speech on campus, and I want to talk about some of the hardest issues that are unresolved that are now arising. The importance of this distinction became clear to me in an event again on my campus, UC Berkeley, in September. You might remember that there was a planned so-called Free Speech Week where for a time it looked like Milo Yiannopoulos, Ann Coulter, Steve Bannon, and Charles Murray all were going to appear. In anticipation of this, the Chancellor, Carol Christ, convened a faculty panel. It was an auditorium about this size, but every space on the floor in the aisles was filled with people sitting. On the faculty panel was one of my colleagues, and he began by saying that the largest problem in our society is white supremacy, and the Chancellor should exclude any hateful speakers. It doesn't matter what the First Amendment says or the law requires. There was resounding applause from the audience. Then in the question and answer period, one of the students spoke eloquently and powerfully about how she feels threatened when there's a hateful speaker on campus. And she said to the Chancellor, "Stand up for us on campus. Don't allow these hateful speakers. Doesn't matter what the First Amendment of the law says. Stand up for us, your students." There was resounding applause. Towards the end of the discussion, I spoke up as a member of the panel, as a lawyer, as somebody who teaches rights about the First Amendment. And I said, be clear, if Chancellor Christ were to exclude speakers like Milo Yiannopoulos or Ann Coulter, she would get sued. She would lose. When Auburn University excluded white supremacist Richard Spencer, he and his supporters sued. They won. Said Auburn University had to pay, Berkeley sued, it would have to pay attorney's fees. In fact, since the law here is so clearly established, Chancellor Christ risks being held liable for money damages. I said the excluded speakers would make themselves out to be victims or martyrs. Nothing would be gained. They'd get to speak anyway. No one applauded when I said that. Well, let me try to explain to you tonight why I come to that conclusion and why it seems so clear to me that campuses must include even the offensive, even the hateful. I want to summarize current law for you in 3 points. First, all ideas and views can be expressed on a college campus. I am here speaking primarily about public universities. The First Amendment, and more generally the Constitution's protections of rights and assurance of equality, apply to the government. Generally, the Constitution doesn't apply to private conduct. This is one of those basic principles of constitutional law, one of the least understood. There's an incident this past fall, you might remember, where President Donald Trump said that football teams should fire football players who don't stand for the national anthem. I got a call from a reporter from a major newspaper, and he said, wouldn't it violate the First Amendment if a National Football League team fired a football player for not standing for the national anthem? I said, the First Amendment and the Constitution apply only to the government. Football teams are private entities. They don't have to comply with the Constitution. The reporter responded by saying, Professor, are you sure about that? Yes, I'm sure. Now, while the Constitution applies only to the government, there are other sources of law that can regulate private universities. Here in California, there is the Leonard Law. It says that private college universities, for that matter, private high schools, cannot punish speech that a public institution could not punish because of the First Amendment. Also, student handbooks and faculty handbooks often provide an assurance of free speech. Many courts have held that those handbooks constitute a contract with students and faculty. Focusing on the First Amendment, the United States Supreme Court has often said that above all it means that the government cannot regulate speech, create liability for speech, punish speech based on the viewpoint expressed. This is so even if the message is offensive, even deeply offensive. Let me give you an example of a Supreme Court case from earlier this decade, Snyder versus Phelps. It involves a small church out of Topeka, Kansas, the Westboro Baptist Church. They make it a practice of going to funerals of those who died in military service and using that as the occasion for expressing a vile, anti-gay, anti-lesbian message. Matthew Snyder was a Marine who died in military service in Iraq. The members of the Westboro Baptist Church traveled to Maryland, where his funeral was being held. Before the funeral service, the members of the Westboro Baptist Church, led by Fred and Margie Phelps, asked the police officers where they could lawfully stand. The officers pointed an area about 1,000 feet away where the funeral service would be conducted. Before the funeral, the members of the Westboro Baptist Church chanted and sang. During the funeral, they were silent, but they held up signs. On the night of the funeral, Matthew's father, Albert Snyder, was watching the news. He could read what was on the signs. He was deeply offended. He sued for intentional infliction of emotional distress and invasion of privacy. A jury awarded him $10 million. But the United States Supreme Court, in an 8-1 decision, held that the members of the Westboro Baptist Church could not be liable. Chief Justice John Roberts wrote the opinion for the court. He was emphatic. The government cannot create liability for speech or punish speech on the grounds that it's offensive. Second principle, free speech is not absolute. There are categories of unprotected speech. We're all familiar with the famous saying of the late Justice Oliver Wendell Holmes, "There's no right to falsely shout fire in a crowded theater." In countless ways, the law can regulate speech. Perjury, lying in court under oath, is speech, yet of course it can be punished. At least since 1942, in Chemerinsky versus New Hampshire, the Supreme Court has said there are categories of speech that are unprotected by the First Amendment. As an example, child pornography is a category of unprotected speech. The law is clear that not only can the government prohibit the sale or distribution of child pornography, but a person can be punished for possessing it, even in one's home. False and deceptive advertising is another category of unprotected speech. There are three categories of unprotected speech that are relevant to discussing free speech on campus. The first of these is incitement of illegal activity. And it's important for this and all the categories to separate the legal test that's used as opposed to the more colloquial use of the word or phrase. The Supreme Court has given us a legal test for when speech amounts to incitement of illegal activity. It comes from Brandenburg versus Ohio in 1969. There, the Supreme Court said that advocacy can be punished if there's a substantial likelihood of imminent illegal activity and if the speech is directed at causing imminent illegal activity. To make this less abstract, I want to contrast two examples. First illustration, imagine a college campus, and imagine there's an angry crowd. Imagine there's a speaker who says to the crowd, "Go commit acts of vandalism, light the building on fire," exhorts the crowd to commit crimes. And imagine that the speaker is then prosecuted for incitement. I think of the facts I described, the speaker could be punished even though all he or she did was engage in speech. Compare that to a very different example. Imagine that someone like Milo Yiannopoulos or Richard Spencer comes onto campus. And imagine there's an angry crowd that reacts against the speaker. Can the speaker then be punished for incitement? No, because it's not that the speaker was advocating that the crowd react against him. And there's a more general principle of the First Amendment that the reaction of the audience can't be a basis for suppressing the speaker. Can't let the fact that the audience is angry be a justification for silencing someone and keeping them from being able to speak. A second category of unprotected speech that's relevant to our discussion tonight are true threats. The phrase true threats comes right from the United States Supreme Court. It originated in a case in the mid-1960s, United States versus Watts. It follows a federal statute that makes it a crime to threaten the President of the United States. The Supreme Court upheld the constitutionality of that law, but the court said it's important to draw a distinction between mere hyperbole which is speech that's protected by the First Amendment, and a true threat. Courts still struggle with defining what a true threat means. There's actually a split among the federal courts of appeals in terms of the definition. I think the better approach is to say there's no First Amendment right to cause a person to reasonably fear for imminent harm to his or her physical safety. Again, let me give you a couple of examples. Imagine that there's a student who's walking across campus. Imagine an angry crowd surrounds that student, and they yell things at the student that cause him or her to fear for physical safety. If the student reasonably fears for imminent harm, that's an assault. That's a true threat. That's not speech protected by the First Amendment. But compare that with another example. Last fall, when there was anticipation of Free Speech Week at Berkeley, I heard many students, especially undergraduates, say that when there's a hateful speaker on campus, they feel threatened by that person's presence. That's not enough to be a true threat. No court would say that that's a basis for suppressing the speaker. A third category of unprotected speech is harassment. There's not much law yet in terms of when on a college campus speech crosses the line to harassment, but there is a good deal of law in the context of the workplace. To pick the simplest example, imagine that an employer says to an employee, "Sleep with me or you're fired." It would be no defense for the employer to say, "But it was just words, it's speech." That employer surely could and should be held liable. In the context of the workplace, courts have said that speech rises to the level of harassment if it's directed at someone or if it's sufficiently pervasive to materially interfere with employment opportunities based on race, sex, religion, sexual orientation. I think it's the same standard that should be used on college campuses. It can be harassment if it's directed at somebody, or if it's so pervasive as to materially interfere with educational opportunities based on race, sex, religion, sexual orientation. Again, to make this less abstract, let me compare it to two examples. There was an incident at the University of California, San Diego, where someone put in the library what looked to be a noose. There was an incident at Duke University where someone draped over a tree branch what appeared to be a noose. I think that is incredibly vile and offensive, but it wouldn't amount to harassment by itself. It's not directed at anybody. It's not pervasive. By contrast, imagine that somebody tacked what appeared to be a noose onto a door in a dormitory where the room is occupied by an African-American student. I have no doubt that any court will be willing to find that to be harassment. Of course, as to this category, like the others, there's line drawing, and it's going to need to evolve over time, but at least we know what the categories are of unprotected speech. And so I've talked about incitement of illegal activity, true threats, harassment. You'll notice what I didn't list as a category of unprotected speech, and that's hate speech. So often I've been asked by people, where is the line between free speech and hate speech? And the answer is, that's drawing a false distinction. Under the Constitution, hateful speech is generally protected by the First Amendment. You might remember an incident in the late 1970s and early 1980s where the Nazi Party wanted to march in Skokie, Illinois. Skokie is a suburb of Chicago. At the time, it was predominantly Jewish. There were a large number of Holocaust survivors. That's why the Nazi Party chose it as the place for its demonstration. Every court to rule, including the United States Supreme Court, held that the Nazi Party had the First Amendment right to demonstrate in Skokie. Or another example is a Supreme Court case from 1992, RAV versus City of St. Paul. St. Paul, Minnesota, after a series of racist incidents, adopted an ordinance prohibiting burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. These are vile symbols of hate. Yet the United States Supreme Court unanimously declared the St. Paul Ordinance unconstitutional. Or yet another case, Virginia versus Black in 2003. Virginia adopted a law that prohibited cross-burning. It did so in light of the history, this being a symbol of oppression and hate in Virginia and the South. The Supreme Court, 8-1, held that cross-burning is speech protected by the First Amendment unless it amounts to a true threat. Or to bring this to what we're talking about tonight, in the early 1990s, over 350 colleges and universities across the country adopted so-called hate speech codes. Every one of them, to be challenged in court, without exception, was declared unconstitutional. Why is it that hate speech is deemed to be protected by the First Amendment? After all, most European countries have laws that prohibit hate speech. I think some of the explanation is how difficult it is to define what's hate speech in a manner that's not unduly vague or overbroad. The law is clear that if the government's going to regulate speech, it has to be specific about what's prohibited and what's permitted, and the regulation can't be any broader than necessary to achieve the government's purpose. Focus here on how both in the United States and European countries, there have been efforts to try to define what's hate speech. There were a series of racist incidents at the University of Michigan, and they decided to adopt a hate speech code. They decided to copy the language from that's found in many West European nations. It prohibits speech that stigmatizes or demeans on the basis of race, sex, religion, sexual orientation. But what does it mean to stigmatize or demean? Can a reasonable person really know what speech is allowed and what's prohibited? The challenger to the University of Michigan Ordinance and Hate Speech Code was a sociobiology graduate student. He said his research was primarily about whether there's inherent behavioral differences between men and women. He said he was worried, depending on what his research demonstrated, he might be seen as stigmatizing or demeaning on the basis of sex. Federal District Court declared this ordinance unconstitutional on vagueness and overbreadth grounds. I think, too, the experience under these campus hate speech codes and in Europe should cause us some pause about embracing them. At the University of Michigan, after it adopted its hate speech code, before it was struck down, every enforcement action under it was brought against African American and Latino students. When England adopted its first hate speech law, the initial prosecution under it was brought against a Zionist group. The prosecutor claimed that Zionism should be regarded as a form of racism. France has a very strict law prohibiting hate speech. One of the most frequently prosecuted individuals under it is the actress Brigitte Bardot. She's an animal rights activist. She's often criticized religions that engage in ritual sacrifice of animals, and as a result, she's been prosecuted many times under France's hate speech law. But perhaps most of all, American courts have said that hate speech is protected by the First Amendment because it expresses an idea. It's a vile idea, but it's still an idea. The late Justice John Marshall Harlan said, "To censor words is to censor ideas." He said, we can't cleanse the English language to please the most squeamish among us. There is a third principle, and that's that campuses can use time, place, and manner restrictions so long as they leave adequate places for communication. The law is well established that even when there's a First Amendment right to use government property for speech, it's not absolute. The government has latitude to regulate the time, the place, the manner. The key limitation is there's supposed to be alternative places available for communication. I think that campuses can use such time, place, and manner restrictions to prevent disruption of campus activities and also protect safety of students, staff, and faculty. In terms of preventing disruption of campus activities, it's constitutional for a college or university to say, no protests or demonstrations in classroom buildings while classes are in session. A campus can have a free speech zone, so long as it's ample in its size and its availability. Campuses also can use time, place, and manner restrictions so as to ensure safety. Campuses have both a legal as well as an ethical duty to protect the safety of their students, staff, and faculty. Last summer, when I arrived at UC Berkeley, the Chancellor, Carol Christ, was kind enough to ask my opinion about some of the speech issues that were being faced. My advice was, I said, I'm not campus counsel, but I'd say, to the greatest extent possible, have controversial speakers be in an auditorium, not in the open area of campus. If a speaker is in an auditorium, then the campus can require tickets or identification for attendance. There can be, if necessary, metal detectors. It's possible for police to secure the perimeter. If there's a speaker in the middle of campus, like UC Berkeley, Sproul Plaza, it's impossible to do those things. The hard issue that campuses, including Berkeley, are now facing is the question, how much are they required to spend in order to protect safety of students, staff, and faculty? Where is the point at which a campus can say, we just can't afford the safety costs, and given the threat, we're therefore going to cancel the speaker? UC Berkeley spent $3.9 million this past September so as to ensure safety for the speakers who came and who plan to come. That's $3.9 million that could have been used for scholarship for students or for the educational mission of the university. Chancellor Christ also asked me the question that I've just posed to you. At what point can she say, we can't afford the security, therefore we're going to cancel the speaker? And once more I said, I'm not your attorney, you got campus counsel for that. But if I were, I would tell you, the law in this area is uncertain. The most that I could reasonably, or any of you could tell you, is you have to spend a reasonable amount. Now, she's way too polite to roll her eyes at me, but the reality is that doesn't provide much of an answer. And so I said, I think you have to consider two questions. First, what is your stomach for litigation? If you exclude a speaker because you don't want to bear the cost of security, you will get sued. The law here is completely uncertain. You might lose, and if you lose, you have to pay attorney's fees. And second, what do you want your message to be? She decided last fall she wanted the message to be that Berkeley is a free speech campus, and she said she would do everything she could to facilitate all of these or any speakers coming, even at great cost. But what if it wasn't Free Speech Week that cost the campus $3.9 million? What if the group declared its free speech semester and it was $50 million? Surely there's a place to which the campus can say, we can't afford it. And should it really be the campus that has to bear these costs? This past fall, I testified in Sacramento before the Senate Judiciary Committee, and I suggested that it should be the state that helps to bear these costs, because the campus here is really providing a public function for all, not just on campus, but everyone. So these are the basic principles with regard to free speech on campus. Let me apply them to some of the most controversial and difficult issues that are arising. And I want to talk about several of them. One issue that's arising a lot now is so-called no platforming. No platforming is where students who don't want the university to provide a platform for a controversial speaker react in a way to keep that speaker from being heard. There was an incident at the University of Oregon this past fall where the president, Michael Schill, was going to deliver a State of the Campus address, and a group of students chanted and sang and hummed so he couldn't be heard at all. There was an incident at William and Mary College of Law this past fall where an ACLU speaker was coming to talk about the events in Charlottesville. Those from Black Lives Matter came and intentionally made so much noise, the speaker couldn't be heard at all. There was an incident at the University of California, Irvine, several years ago, when I was there, and involved Israeli Ambassador Michael Oren. As soon as he came to the lectern to speak, students stood up in the back of the room and yelled so Ambassador Oren couldn't be heard. The student was escorted away. Ambassador Erwin started talking again. A second student stood up and yelled so Ambassador Erwin could be heard. That student was escorted away. This went on altogether with 11 students in turn standing and yelling down Ambassador Erwin. He then was able to deliver his prepared remarks. At that time, and at the University of Oregon, and at William and Mary, and at so many other places, the students who are doing this claim that they have free speech, and they should be able to use their free speech to keep someone who they don't want to have on campus from having the platform there. I think the law is clear that what the students are doing in these instances is not speech protected by the First Amendment. There's no right to use speech to silence an invited speaker. Otherwise, there would always be a heckler's veto. Otherwise, any audience could silence a speaker just by yelling or singing the speaker down. Then the only speakers we'd ever get to hear are those that the audience doesn't care enough to silence. Second issue that's much talked about on college campuses is so-called safe spaces. And if you spend any time on college universities, you've probably heard that phrase. I think we have to be very careful about what we mean by safe spaces. Some of the meaning is quite laudable. Some is objectionable. If safe spaces means the duty of the campus to protect the safety of students, staff, and faculty, unquestionably that's right. Safe spaces might be about a place of repose. We all need a place to get away from it. And the Supreme Court has said that there can be more restrictions of demonstrations outside of a person's house for that reason. It's a case called Frisbee versus Schultz. Likewise, I think that college and universities can have more restrictions of speech in and near dormitories than in the public areas of campus, so long as the restrictions and rules are viewpoint neutral. But what safe spaces must not mean is that we're going to protect students from ideas that make them feel uncomfortable. I've often thought that one of the things about higher education is that we are exposed to things that might make us feel uncomfortable or even offensive. We can't make college students safe from that and still fulfill our basic mission as college or university. A third concept that's much discussed now is often called trigger warnings. Trigger warnings are where a professor gives a warning to students before covering material that might be offensive. I confess to you, I've been giving trigger warnings in my class long before I ever heard that phrase. When I teach First Amendment law, I play for my students the George Carlin monologue on the 7 dirty words. It's the focus of a Supreme Court decision, FCC versus Pacifica. I think it's only possible to appraise the case if the students hear it for themselves. But I've always told the students before playing the monologue that it's filled with profanities and sexual innuendo. I even say, if they want to, it's 5 minutes long and they can leave the room and come back. I've never had a student actually leave rather than hear the George Carlin monologue, but I've given them a trigger warning. When I taught the class on free speech on campus the last 2 years, my co-teacher Howard Gilman and I began by telling the students of an incident that occurred at the University of Oklahoma in March 2015, where some fraternity members, on a bus of fraternity members, led a very racist, offensive chant. I said, we're going to read to you the words of that chant so we can talk about whether or not it's protected by the First Amendment. We told them that material that could be quite shocking and offensive. It was a trigger warning. So I have no problem with professors, if they think it's appropriate, giving such warning to students. My concern is that at some places, this consideration whether faculty should be required to give trigger warnings. At University of California, Santa Barbara, at Oberlin College, and such proposals. And I very much disagree with those. I think that it's got to be for the professor as a matter of academic freedom to decide how to best cover and teach the material. There are times where I think it's better to let the students be surprised and even shocked. Sometimes it's better to give warnings, but it has to be in the context of what's the best for the education of the students. A fourth concept that's much discussed is microaggressions. Again, if you spent time on campus, you've heard this phrase. A microaggression is speech that's offensive to another, though it wasn't intended to be offensive. It's speech that's hurtful, but it wasn't meant to be hurtful. Now, when I say this, I've sometimes been accused of engaging in political correctness. I strongly disagree. We all learn from a young age that there are things that you shouldn't say to another person because they're hurtful. There's things that we don't say in public. I think we should educate college students about what those things are, what might be hurtful, offensive to classmates. A fifth and final area where the law needs to develop concerns the internet and the First Amendment. I think that the hardest issues with regard to free speech on campus are going to involve the internet. Courts are just beginning to deal with these. The internet is the most powerful medium for communication to be developed since the printing press. The internet and social media tremendously democratize the ability to reach a mass audience. It used to be to reach a mass audience, you need to be rich enough to own a newspaper, get a broadcast license. Now, any of you with a smartphone or just access to a modem in a library can reach a mass audience. There's great benefits to that, but there's real harms too. Makes it much easier to disclose personal information about somebody. Makes it much easier to engage in harassment. Makes it much easier to troll somebody and to disrupt their lives. When we think of free speech on campus, I said in my introduction, we think of students on campus engaging in speech. But when we deal with the internet and social media, that distinction on campus and off campus has no meaning. So courts are only beginning to deal with issues concerning the internet and social media, but I think these are the ones that campuses are going to have to face in the years ahead. So I've tried to describe for you the current law, some of the issues that are arising with regard to free speech on campus. I want to conclude by emphasizing that at the same time I believe that colleges and universities have the obligation to create an inclusive learning environment for all students. It can't come by suppressing speech, but that doesn't in any way lessen the obligation of campus officials to do everything to make sure that for all students, and particularly for underrepresented students, that campuses are hospitable environments. There's so much that campuses can do in this regard. I think that every campus should have principles of community that describe how we desire to talk to one another. I've often said, as I've written these for my students, that there's a tremendous difference between having the right to say something and believing that it should be said. And campuses should guide students in that regard. That doesn't mean that violations of the principle of community are enforceable by discipline, but it helps to educate students, staff, and faculty. When there are hateful incidents on campus, it's essential that campus officials respond and respond strongly. When the swastika was drawn over Alan Dershowitz's picture at UC Berkeley Law School, I learned of it at 4 o'clock on a Wednesday afternoon. At 8 o'clock on Thursday morning, I sent a note to all students, staff, and faculty condemning the swastika, talking about why it's inimical to the kind of community we are and desire to be. Remember that Justice Oliver Wendell Holmes said that the best remedy for the speech we don't like is often more speech. I'm not naive. I don't believe that more speech can necessarily cure the pain or the hurt from hateful speech. But I believe that campus officials can do an enormous amount when they speak out against hate and proclaim the kind of community that they want the campus to be. I think campus officials have the duty to help students organize counter-demonstrations, to react in a constructive way to the offensive or hateful speech on campus. I'll give an illustration. When Richard Spencer spoke at Texas A&M, a counter-demonstration was organized in the large football stadium. Thousands, maybe tens of thousands of people came. I've talked about students and faculty who were there. It was a very unifying experience, but otherwise been very divisive for the campus. There can be leaflets, counter-demonstrations, teach-ins, all as a reaction for offensive speech. So I've described for you the current law. I haven't tried to persuade you about whether it's desirable or not. It's really a separate conversation. But I have to also tell you that overall I believe that the Supreme Court has gotten it right in this area. I realize that the only way that our speech can be secured tomorrow is to protect the speech that we detest today. We don't need freedom of speech to protect the expression we like. We would let that go in anyway. We protect freedom of speech to protect the speech we don't like, so everyone's rights will be secure tomorrow. This is based on a faith. Ultimately, the faith is we're better off letting all the ideas and views be expressed than letting government officials, including campus officials, pick and choose about what speech to allow and what speech to prohibit. I share that faith, at least most of the time. Thank you. And I think at this point, delighted to take questions. There are people with microphones, so I think what I'm going to do is let the people with microphones decide who gets to ask questions, so that way I can't be accused of suppressing anyone's speech.
I guess I get to ask the first question. Thank you so much for your words and living up to the introduction. That was a terribly engaging talk.
Thank you.
And I admire your ability to do what you just did without any notes. It is remarkable.
Thank
we
you.
are honored
We're very
to have
kind.
you here.
Again, thank all of you for coming. This is amazing that you're all here on a Thursday night when you could be watching NCAA basketball. So thank you for coming.
My question relates to Leonard Law. I am no lawyer, but
Sure.
I have tried to look into this a little bit as it relates to private universities in California.
Sure.
And I've read up a little bit on Corey versus Stanford and how they tried
Exactly.
to enact a speech code, and it was shot down because of how it limited speech beyond fighting words. My question relates to a place like University of the Pacific, which is actually thinking about a speech code and seems to think it can do so because we're a private institution. But as I understand it, it would only be able to do so because of its sectarian status, and yet we're not terribly sectarian at all. In terms of being a United Methodist-related institution, even though we're not terribly Methodist in anything other than that little title. And so that's a complicated question, but I'd like you to, if you could, help us tease out the differences. I don't think we can limit speech because we're private. We might be able to do so because we're sectarian, kind of. Is any of that right, or can you give us some guidance? Because this is a question we're facing
Sure.
right now.
Let's make this a hypothetical university that fits your description. The Leonard Law says that a private university cannot punish speech that a public university would not be able to punish because of the First Amendment. So, the hypothetical private university cannot punish student or faculty speech if it couldn't be punished at the University of California at Berkeley. Now notice that there are ways, though, that the campus of a private university has more latitude to regulate speech than a public university. A public university is obligated to make available space for speech. At least some part of the campus is, in the language of the First Amendment, a public forum. No part of a private university is. And if a private university wants to close its space to speech, it's going to have more latitude to do so. Now, even here, there's some uncertainty in California law. The California Supreme Court in Pruneyard versus Robbins said there's a right to use shopping centers for speech under the California Constitution. There's a right, therefore, perhaps to use parts of campuses for speech under the California Constitution as well. The bottom line is that Corey versus Stanford University struck down the Stanford hate speech code. I think that the speech code at this hypothetical private university would be struck down the same reason that Corey versus Stanford University was. The same reason that the University of Michigan or the University of Wisconsin or the George Mason hate speech codes were struck down. Does it matter that it's sectarian? I think if it involves the religious mission of the university, and if it involves religious-related speech, I think it poses a different issue. There hasn't been such a challenge that I know of with regard to the Leonard Law. But I think the hypothetical university would really have to tie the restriction on speech to its religious mission to distinguish Corey versus Stanford University, not just say we are loosely affiliated with this faith. And I'm going to let whoever's got the microphones decide who to give them to.
Sorry. My name is Liana. Go to Ben. I'm a senior, so I apologize if my question is not.
No. Anything.
Yeah. So recently, when you talked about the internet, recently there was a problem where a student at University of Alabama, I believe, posted on her private Instagram that only her, she can decide who can see it and who can't. A video of her saying really racial slurs, the N-word with the hard R, saying she hates the N-word with the hard R. And it went viral. Someone leaked it and everyone saw it. And I believe that she was expelled from the University of Alabama.
Yeah.
Can they do that?
Well, two different questions. Can they do it? And if they get sued, will they win?
Yeah.
They did it. I think if she sues for her expulsion, she'll clearly win. You can't say that what she did was incitement. You can't say that what she did was a threat to anybody. She wasn't harassing anybody. It wasn't directed at anybody. It's ugly. It's offensive, but it's protected by the First Amendment. There was an incident at UCLA a couple of years ago where a student there put on YouTube a very ugly anti-Asian rant. There was talk, could the student be disciplined? The answer is not consistent with the First Amendment. People have the right to say ugly things, and the campus can't punish it under those circumstances. Now, the campus officials may have chosen to expel her knowing that if they got sued, they would lose because they were trying to make a statement. I mentioned the incident at the University of Oklahoma in March 2015. It was a bus filled with fraternity members, all dressed in formal wear, and two members led the others in a racist, offensive chant that praised lynching. When a member of the fraternity who was on the bus took a video and it went viral, and when the president of the University of Oklahoma, David Boren, saw it, he immediately expelled the students from school and he suspended the fraternity from operating on campus. I was at an event on speech that was sponsored by the Civil Rights Division of the Department of Education, and one of the people there was the general counsel of the University of Oklahoma, and he said that the president knew when he did this, if he got sued, he would lose. But he thought it's so important to make the statement against racist speech, he was willing to do that. I don't know in terms of the University of Alabama, but it might be that was true there as well.
Thanks. Really good speech, by the way.
Thank you.
Yeah. I've heard of this thing called SLAP lawsuit. It's strategic litigation against public participation. I think most states tend to have some sort of precedence with that. But do you know if California has anything?
California has a SLAP
California has
statute.
that?
Yeah, what this basically says is we want to provide people protections from lawsuits when it's for their speech or for their advocacy activity. And it says that if somebody is being sued for speech advocacy activity, there's all sorts of extra protections that they get as a defense if this is a suit that's really seen as trying to chill speech and advocacy. And California has a SLAP statute, and it's easy to read about it on the internet.
Okay. I was just...
And the statute is not new, and it's worked very well. Most states have the anti-SLAP statutes, but it's all about trying to people from weaponizing litigation to try to chill speech by bringing lawsuits. It provides greater protections for the defendants, higher thresholds that the plaintiffs have to meet, attorney's fees, and things like that.
Yeah, I was going to say there seems to be an issue with that, where a lot of these free speech cases, some of these NGOs, claim to be NGOs, are raising lawsuits against participants, and I guess some of the things like...
Yeah, and that's where SLAP suits can come in. And I think we can certainly talk about ways in which the SLAP statute, the anti-SLAP statute, could be modified. But overall, it's not new, and it's worked well.
Okay. All right.
Hello. Oh, I have a question about just the idea of when a speaker is invited onto campus. Have you come up with the argument or something that if a speaker is invited onto campus, then the campus is kind of implicitly at least interested in the ideas that the speaker is going to present on, and how does that figure into this whole conversation? And also, I'm a theater professor, right? And so in the history of theater, if people in the audience didn't like what was going on stage, they booed or they threw tomatoes or something like that. So what is the dynamic between the examples that you gave where people were vocally protesting what was being said? What is the dynamic between that? And is the silence of the audience, in a way, at least giving the speaker the benefit of the doubt that what they're saying is of interest or of importance? Yeah, it's kind of a convoluted question. But have those arguments come up with these discussions of these controversial speakers, or have you had conversations at UC Berkeley about that dynamic?
Let me take your question in two parts. One is, having a speaker come onto campus is not an endorsement of that speaker's message. I want my law school to be a place where all ideas and views get expressed. That doesn't mean I agree with what's expressed. When I heard that Alan Dershowitz wanted to speak at UC Berkeley, I picked up the phone and said, I don't know him well, but you're welcome to come speak at this law school anytime. I don't agree with Alan Dershowitz's views about the current policies of the Israeli government, but I want him to be able to speak. And then the students, the organization called Students for Justice in Palestine, were very upset that Alan Dershowitz was coming to speak. And I said, you can invite any speaker you want on the same terms that Dershowitz is coming, and I will facilitate that, because that's what a campus should be. And I don't agree with what that speaker said with regard to Israel and the Palestinians. So it's not that I or the law school is endorsing them by having them come, but I think that if it's going to really be what a college university should be about, is all ideas and views. The whole range should be expressed. But it's not an endorsement of what's said. Now, as to the latter part, remind you, the latter part of your question was about throwing things, theaters, and throwing tomatoes at things. And in light of that, I'm glad that no one threw tomatoes or anything at me there. I think there was some vegetables out there in the reception. I think the key is that the audience can't be able to silence the speaker. That there shouldn't be able to be a heckler's veto. Because otherwise, as I said, I worry the only speech we'd allow is that which nobody cares enough to silence. So an audience can certainly respond, but not in a way that keeps the speaker from being able to be heard. If you don't like what I say, you can boo at the end of it. It's even okay to hiss me, but it's not okay to sing and chant and hum so that I can't express my message when I'm an invited speaker here. There can be very effective silent protests. Chancellor Christ told me that when she was president of Smith College, Ann Coulter was coming to speak there. And the women there organized a silent protest. That as Ann Coulter began to speak, a group of women stood up, turned their backs on Ann Coulter, and walked out. And then another group of women stood up, turned their backs on Ann Coulter, and walked out. And so on, so that by the time she was done, there was an almost empty auditorium. That didn't disrupt Ann Coulter. She was able to deliver her message, but it was a very powerful way of expressing disdain for Ann Coulter and her message. That's fine. Throwing tomatoes at Ann Coulter wouldn't be okay. Yelling Ann Coulter down wouldn't be okay. So that's where I draw the distinction. I think that's where the law draws the distinction, is to the second part of your question. I think you got the microphone.
Yes. Okay. Incident at Harvard where there was a private Facebook chat group among people who were recently admitted, and they got their admissions rescinded because of
Last year.
offensive speech. What is your opinion on that?
Okay. This occurred last spring. It was a Facebook group of students who'd been admitted to Harvard, and they said very offensive things, and Harvard rescinded their admissions. Now, keep in mind that this is a private university. The First Amendment doesn't apply. We can talk about this in terms of what if a public university did that, or we could say, what should Harvard have done? Because I think the same free speech principle should apply at Harvard as at UC Berkeley. Here's what makes it difficult. If the students were already on campus and said those things, I think it's clear under the First Amendment as a public university, they couldn't be expelled for doing so. Nothing they said would remotely rise to the level of speech unprotected by the First Amendment in a basis for expulsion. But what if they hadn't been admitted yet? What if, as part of their essays for admission, they said really offensive things? Well, part of accepting students is a sense of their judgment. And I'm troubled by using speech, but if I was reviewing an application and a student used racial epithets in a very offensive way, I think I would decide I don't want to admit that person to my university. The question with regard to what Harvard did is, once they've been admitted, is it more like the former, they're being on campus and punished for speech, or is it more like the latter, making the judgment before the acceptance has been issued? My own conclusion is it's more like the former. Once they've been accepted, they're part of the school, even if they're not on campus. And I don't think they should be able to be punished for speech, but they couldn't be punished for it if they were a student there. But it's a hard question, but that's why I think it's difficult. Judge Callahan.
Dean, I have a question that I guess I want to kind of ask is, you as a dean, you as a father, and we have all these students here, many of them who want to become lawyers. And you said, well, you can't throw fruit, you can't shout people down. What the students probably need to think about, what sort of conduct would get them arrested and might make it difficult for them to become a lawyer?
That's a great question. Getting arrested, getting convicted, does make it harder to get admitted to be a lawyer. The bar takes those things into account. Obviously, anything that's a crime, acts of vandalism, any destruction of property. There's no First Amendment right ever to destroy property. Engaging in the kind of behavior that I talked about that's not protected by the First Amendment, such as incitement or true threats, that can get arrested. Disorderly conduct. Now, I'll also tell you there's a California statute that makes it a crime. It's a misdemeanor to disrupt a public meeting. The 11 students who disrupted Israeli Ambassador Michael Oren were prosecuted and convicted for disrupting a public meeting. Now, I think their speech was not protected by the First Amendment. I also don't think they should have been criminally prosecuted for what they did. And the week that the incident occurred, I wrote an op-ed in the LA Times saying that there's no First Amendment right to use speech to silence another. They should be disciplined by the university. But I think there should only be criminal prosecutions on campus if there's a real threat to persons or property. After they got convicted, I wrote an op-ed in the Orange County Register saying their speech wasn't protected by the First Amendment, but I think it was an overreaction by the district attorney to criminally prosecute them for this. But I use this, Judge Callahan, to answer the question. Disrupting a public meeting is a misdemeanor in California.
Well, and they can't always hope to have a constitutional scholar review their application for the bar, right?
Nor
I
are
just
the
want them.
police.
I just
Right.
want them to think.
Right. Nor are police at the moment constitutional scholars. That said, there is a First Amendment right to engage in protest activity. There is a First Amendment right to demonstrate. But I think it has to be done in a way that doesn't violate the law. Violating the law, there's no First Amendment excuse for violating the law. I remember when this occurred in the Irvine campus, the response I got from the students was, well, they're engaged in acts of civil disobedience. I said, yeah, but when you engage in an act of civil disobedience, you're accepting that you can be punished for it. The fact that civil disobedience doesn't give you a get-out-of-jail-free card or say that the law doesn't apply to you. And that's something important to realize, too.
We need the Erwin Chemerinsky hotline
Yeah,
for
yeah.
students. Thank you.
There's more questions.
I'm sorry, Dean. I want to go back one more time.
Sure, I don't know. Wave your... got it.
So my question is about the Secretary of Education recently, or just about a few months ago, I saw that she had visited a campus and she was talking about education policies that she was hoping to set. And I was seeing that in the video, a lot of the students were, like she would ask a question, like she would be talking and then they would like interrupt her and be like, that's not okay. Or they would say, she'd be like, is that technically what we want for our students? And then they'd be like, yes, it is, or no, it's not, or, they would like, in a very loud way, and it was majority of the auditorium. Sure. So is that protected under free speech, or is that not?
I'm going to be the law professor and answer a question with a question. Was she basically able to deliver her message? If she was basically able to deliver her message, the fact that the audience reacted verbally against what she was saying, I don't think is a problem. Was she shouted down so that she wasn't able to speak at all? Well, then I don't think that the audience had the right to do that. It's contextual. Where do you draw the line between the audience silencing the speaker and the audience's ability to express itself without silencing the speaker? So I don't know the incident, but that's the question that would need to be asked. Okay, thank you.
It's interesting to me that when we have these conversations, or I don't know how many times I've had it, but in such a lovely setting, that
it is a lovely setting.
Isn't it a lovely setting? The conversation is constantly about hate speech that is primarily against what I guess would be called suspect categories, which is groups of people who've been traditionally discriminated against. It's probably the mildest word. And why our conversation about the First Amendment, which I would think would be designed to protect the speech of people who have been in those suspect categories and who are attacking those who have put them in discriminatory positions, that rarely even seems to come up. Is that speech happening? And if so, what is occurring around it legally?
Yeah. The First Amendment protects all of the speech you described. The First Amendment protects the speech that's trying to advance the interests of underrepresented minorities and the speech that's hateful of underrepresented minorities. Why are we talking about it the way we are? Well, think about Richard Spencer, who's been going around a college campus in the last year expressing a white supremacist message. Went to Auburn University, as I mentioned. They tried to keep him from speaking. They got sued and they lost. Went to the University of Florida. They spent a huge amount of money so he could speak there. Was at the University of Virginia when the tragic incident occurred there. Wanted to go to Ohio State University, and the university excluded him, saying there's too great a chance of violence. And Richard Spencer is sued, and the case is pending in federal district court in Ohio. We think of Milo Yiannopoulos. Milo Yiannopoulos has gone on to college campuses and publicly disclosed the names of undocumented students and transgender students. This is what we're talking about now because it's what's happening right now. Those aren't the only issues of speech, and I actually think there are much harder issues of speech that are going to come. I'm arguing a case in the Fourth Circuit in May on behalf of women students at Mary Washington University. They were subjected to incredibly vitriolic harassment, and there's no way to describe it except extreme harassment, and the university did nothing for them. Now, I'm not saying the university should have punished the students who engage in speech or shut down Yik Yak. That's not my position. But I do believe under Title IX, this is the federal law that says educational institutions receive federal funds can't discriminate based on sex. Campus officials had an obligation to do something to protect the students from harassment without suppressing speech. These are the issues that are coming up now. Wherever the microphone is.
Good evening. My name is Kareem Ali. We met a few moments ago.
I know you're studying for the bar this summer.
Yeah, thank you. Wish me luck. I need it.
You went to University of Kansas, a
Rock
terrific law
Talk
school.
Jayhawk, you know it, yeah.
They play tomorrow, I think.
Yes, we do. I'm going to kind of take advantage of just having you here for this moment. I'm going to go a little further out. I'm curious, in one of my classes that I teach, Law and Society, I recently introduced to the class the topic of net neutrality. And I'm really curious what your take is on this and the possible effect that it would have on the First Amendment, freedom of speech, freedom of expression, particularly as it involves social media organizing, organizing protest movements and those types of things.
let me separate this into two parts. The first is, at this point, companies like Google or Facebook have tremendous control over speech. If you can't access a website because Google won't let you, it's almost the same as if that website doesn't exist at all. Google and Facebook are not part of the government. The First Amendment doesn't apply to them. And yet we have to be troubled by how much control over speech can be in these private hands and what we should do about it. That then takes me to the issue of net neutrality. I really believe that we need to, when we use social media, the internet, be able to have access to everything as much as possible. I worry that without net neutrality, our ability to have access to information, information vital for our lives, is going to be restricted. And that's why I'm very troubled by the repeal of net neutrality. I think we have time for just one more question, because I know we have to finish. Wherever the mic, okay. Please.
Hi, thank you for your speech. I have a hypothetical question. So say like a certain university has an open public forum to students to talk about like budgeting or some sort of topic. And say, they ask students and like, say the student criticizes the administration for, say something like overspending and to the point.
Why do I think this isn't hypothetical? Go ahead.
Yeah, to the point where they tell you, even though it was for every student, it was allowed to ask questions and stuff like that, you're never allowed to come back. Is that is that like a valid excuse basically to silence the student, or?
Let me start with make it a hypothetical public university.
Yeah.
And imagine at this public university, the student who asks the question of the chancellor, the provost, the dean, is told, in light of that, you're not allowed to come back and ask a question anymore. I would say that's a restriction of speech. It's almost in the language of the First Amendment, a prior restraint. You're told you're not allowed to speak again. So, assuming the hypothetical as we've described it, the disfavored student is told, you're never allowed to come into this forum and speak. That's a restriction of speech. Now, in California, go back to the Leonard Law, it says you can't punish speech at a private university that can't be punished at a public university. What does punish mean? There's not a whole lot of law. I would argue that excluding someone from being able to speak is a form of punishment, and I would say that would violate the Leonard Law. Based on the facts of the hypotheticals we've discussed and knowing no more than that.
Thank you.
Thank you so much.